Okay, are we on?
Yeah.
Okay, great. Okay, so this is the legal committee, July 2nd, beginning with roll call. We have Ronnie, Jenny, Dominic, Margaret. Crystal, I see you online. Can you hear us? Good. And
Yep.
we also have Nathan Woodhall from CAC, because the two issues that we are addressing this evening are coming from CAC. So Nathan's joining us this evening. I see that we have Linda Fenroth. Logan is in the room running the documents. So fairly straightforward this evening. We have two ordinances, one local law, that were brought forward by the CAC. We're going to begin with the public tree ordinance, which you all received. This is about removal of street trees. I'm going to defer to Nathan on most of this. One thing that I did do, which I circulated after the meeting at the CAC last night, I went back to the original ordinance and I pulled out some language that I think might be helpful in our discussion last night. One of the things that the CAC talked about was definitions of public trees and trees that are potentially providing shade on the sidewalk and so forth. So I went back to the original language for that. So I'm going to hand this over to Nathan to walk us through the intent here, and then you can talk about the pieces of this language in the old ordinance I think would be useful.
So I think it's probably helpful to like walk back to the previous attempt at passing a tree ordinance. So that was a much more expansive ordinance. It included a tree board, included regulation of basically every tree in the city of Hudson, whether it's on private property or in public way. That failed past the council. This is an attempt at like paring down to the most essential possible. I think there's like a lot of gradation between those two extremes that the council could choose to go for. And this is the opposite extreme, if I were to characterize it. So there were two pieces of feedback from talking to council folks who this is mostly talking to Tom, that there was a sense of the previous one was overly broad in terms of the number of trees on private property that it would apply to, and also feedback that that creating a tree board was like unwieldy, and we were going to buy into beyond such a thing, and like, do we actually need this new body? So I did go back and try and like figure out if there was some other way to do this. I did talk to DPW and code enforcement. I think there's issues with both it sitting in either of them. And there's a set of legal questions that I think Margaret is running down about whether or not the current enumerated powers of code enforcement or DPW allow them to regulate street trees in a public way. For DPW in particular, which is what this draft contemplates adding responsibility for DPW, they currently regulate, and this is an enumerated power, the addition of street trees, but not the removal. So it does feel like we would naturally list both if you wanted to do this, right? And I have no idea like what's required to amend the charter portion. So I think the overarching context is like the city is currently funding a whole bunch of street tree planting. Is currently there's nothing that stops the adjacent homeowner or business owner from removing a street tree the year after.
Saw it happen this week.
Yeah, the year after the city plants it, basically. And so it's just from like a budget perspective, spending tax dollars on that, it feels like we should be not preventing someone from making that choice. There are also street trees that people take upon themselves to plant. But I guess that's the context for street trees. I think that there's this, the other sets of issues are around regulating. To me, it seems like very straightforward and obvious that the street trees we should be protecting.
Yeah.
I think it's an open question where the council wants to draw the line beyond that. Some of the things that have been discussed in the CAC were like trees that shade the public way being protected. I think that's basically the potential middle ground.
You hold that thought for a moment.
Yeah.
The street tree in this document, the local law, street tree is defined as shall mean any tree located in the public right of way, including but not limited to trees planted sidewalks, tree lawns, or other public easements. In the original document,
This is from the previous.
Yeah. I pulled out the definition of public trees. Any trees, shrubs, bushes, and all woody vegetation on land lying within a public street, public park, or right of way within the city, including any tree or shrub which overhangs any highway, street, sidewalk, or public place. So the thing that was discussed last night was expanding the definition of street tree to include trees that overhang any highway, street, or sidewalk. Because we do have, and so we want to regulate loss of shade on the streets.
Yeah,
We're not saying it couldn't come down, because what it does is it requires a permit.
yes.
So that's the one piece I pulled out about the definition of a street. I think, how do people feel about including trees that overhang the sidewalk as being a public tree?
I like it. And I also like that this language, the old language, also includes parks, which the new language does not.
Ronnie?
Yeah, I like the idea that we can protect any trees that the public benefits from. Just The rest of it is it overreaching? And is there any precedent from other cities that protects it certain, same exact way? And,
Are you okay with the overhang?
Yeah. I'm okay with it as, personally, I'm okay with it. If it's something that benefits the public, we should work to preserve it. More trees, the better, for sure. It's just, do we have the authority to, regulate other people's property?
That's
Things
where it's a permit, they have to get permission to take down something that's overhanging.
Right.
I think,
And what would,
in most cases, you're probably not gonna have a lot of owners who have over trees who are going to want to take down, like in fact, you know this from Westport Street and Partition.
Mhm.
For months I've been dealing with residents who were up in arms because National Grid wanted to very significantly pare back or take down the trees. So people are more likely to not want the tree to be taken down. But I think putting in the overhang gets to that issue of shade.
National Grid specifically, unfortunately, they have an eminent domain.
Mhm.
To
So-
a certain extent.
Yeah.
If it's a new project, they don't. If they have domain if it's maintaining a current program, but.
Yeah, I just want to make clear.
Yes, yes,
Yeah.
but I'm just saying that my encounter of people with older trees,
people would like,
they want to keep.
It depends.
it depends on like if a developer wants to come in and they want to.
There's one particular person I can think of that has taken down trees all over my neighborhood that were beautiful 300-year-old shade trees.
But Dominic, are you
On their own-
comfortable
on their
with
own.
expanding the definition to include trees that
But
are
it was
providing shade?
That are
That are providing, so if you have a tree it's on your property, but it is from the old language, including tree which overhangs any highway, street or sidewalk, public space. So this would mean a tree that might be on my property, but is providing shade on the sidewalk would be covered by this requirement that you get a permit to take it down.
And so, I mean, when you say remove, you talk about removing the tree, not to trim a branch that's
No,
over.
we're not talking about trimming. This is just,
Totally remove it.
right now, we're just talking about the definition of a public tree. So to include trees that overhang the sidewalk.
Okay, so if someone has a yard and you want to remove it to do, put something in there, but it's not hanging over
Then
and,
it's not a public tree.
That's not,
It does not, this does not apply.
gotcha.
And a
Any,
lot of the community pushback on the last iteration
Right.
is for precisely that.
right,
Yeah.
okay. Yeah, I'm good with that, because
Okay.
again, it's affecting the public good.
Okay, so we're good with that definition. So then the other thing from CAC last night was basically if you want to take a tree down, you have to get a permit. Permit application shall include the reason for removal, location of the tree, and proposed replacement plan. It does get the replacement plan. So one of the things that we talked about again last night was adding the age of the tree as part of what the information.
Sure. I mean, I think it'd be pretty hard for a person to know, but yeah.
Well, Hillary had put in,
You could do
Hillary had put in a lot of information about caliper, so
You could do the sort of width of the tree.
so we could, instead of asking about age, we could just say caliper,
Yeah, or
the circumference.
the circumference. I guess I actually don't know the technical terms. I think that there is a term that tree people use and I don't,
It's caliper,
yeah,
and I can never remember.
whether that's radius or.
But if we ask for circumference, then we get some sense of how old the tree is.
Yeah.
and whether it's a significant
So,
tree.
so I guess then to what end would you change anything that the law requires based on tree circumference?
So mainly it's because, replacement,
Mhm.
okay? So let's say there's a street tree
Mhm.
that's not, it's not a danger, whatever, this is not a danger.
Yeah.
There's a street tree on my side,
Mhm.
and I want to have it taken down.
Yeah.
And it's a large tree, and so I'm agreeing to replace it.
Mhm.
But I'm going to be replacing it with something that's going to take 20 years, be of the same
Yes.
stature.
Mhm.
So I think putting that in, putting in the circumference provides some kind of context for whether or not, okay, is this really reasonable to remove this tree?
Okay. Yeah, I think if I were the person who wanted to do the right thing here, right? Like that I had some, to your point, some very old tree, but it was diseased for some reason it hasn't come down, sadly. And I want to replace it.
That would be okay.
Yeah, that would be okay as
Yeah.
written, but like as the part that I was trying to follow is, would I then have to, does that create some expectation that I have a replacement tree?
The old one did.
Yeah.
The old ordinance required that if you were going to, you have to match caliber.
Yeah.
So if you were taking down a big tree, you
Wow.
might have.
Yeah, this is my.
Right.
reason.
But I just really want to put that in there as providing some context for what are we talking about? We're talking about a big tree, a small tree, and also remember that anything that's diseased, or needs to come down, that's different,
Yeah,
and that is addressed.
so I guess I was, if there was going to be a requirement to measure the tree, then is there, like, is an explicit requirement to replace like to like, then,
No,
okay.
I think.
So this is where I was getting.
So leave it out. Leave it.
Okay, this is where I was getting.
Yeah, I don't,
Let's
yeah,
leave it out.
Yeah.
That wouldn't be possible.
How do you feel about asking that as part of the application, you provide a photograph?
Sure. I mean, whatever's,
Simple.
whatever's fine, I mean.
Oh, we can leave it out.
should we have someone verify that the tree would be a danger?
So dangerous trees, Margaret raised this as well, we chatted maybe a month ago. This doesn't, I think when Margaret and I talked about dangerous trees, I think you also spoke with Craig about this. He does not currently believe that he has the authority as code enforcement to force someone to remediate a dangerous tree. Even if it is a dangerous tree.
It's not public tree, this is on their.
This is on their property. This was a separate, I think there's a separate issue Margaret raised, we spoke,
Well,
which was,
there are plenty of
Yeah.
homeowners or business owners or developers, and I can think of two right off the top of my head, who like to take down trees because they see them as a liability, that they might be struck by lightning or
Yeah.
that a tree limb might fall or
Mhm.
whatever, so they just take out all the trees.
and maybe misremembering the anecdote that you told me, but it was that you had sort of the opposite problem that a constituent had, which was like obviously dead or diseased
Yeah.
tree and a property owner who was just like, I don't care. And
Yeah.
the adjacent owner
Yeah.
was like, let's go fall in my house.
Right. That's happening to a neighbor of mine, but, you know, there is
Yeah.
both ends of this, but if you had to have an arborist say, hey, this tree is dangerous.
Well, we've left that out.
It's
We've
left
left
out.
that out.
I just wanted to say that we did, I think, email at one point about the possibility of there being another regulation to handle this, clarifying the code enforcement. For someone to deal with, if that was, but yeah, I think that's a separate issue.
Yeah.
And this is really just as currently written about DPW. This is the other problem is that DPW regulates currently streets, but not private property in any way. Code enforcement regulates private property safety. So it does feel like there's sort of two domains, and there's like this sort of tricky middle ground.
Am I understanding it correctly that currently Craig believes that he has no authority to compel a homeowner to cut down a tree?
Right?
Yeah,
That is
okay.
correct, yes.
Even if it is a tree that has like a limb that
That
is
is
on the
correct.
public way.
Yes, there was an instance where there was yes, there was and actually he cited the quote to me, and Crystal, you can weigh in on this. There was an instance of a tree that was damaged in a storm, half of it fell down. The other half was, very dangerous. And the person who took away the half that fell down said that other part needs to come down. And it was very, very difficult to get, it was absolutely landmark, very difficult to get this individual to move it. And Craig said there was nothing in the New York State code that allowed him to regulate, that he could regulate. I'm like, well, this is crazy. You can give somebody a citation for having a grass tree on, but you can't give them a citation for having it damaged.
It's because there's a local law that gives
Right.
that. Yeah.
So yeah, we should definitely address that.
But I think we don't want to get into the private trees because we want to try and keep,
Okay.
keep to the public ones. There is provision in here to allow for if, you know, you don't have to get a permit if you have an emergency situation and you want to take it back. So that's okay. The only other piece that I pulled out this morning from the old ordinance, where I think we might want to put it in, it's item B on this page I gave you. All three shall be removed to an appropriate location and not left in public. I think we should have.
Which one is that?
It's B.
It's on this
B.
separate page, but all the three shall be removed. I think we should have that. But beyond that, I think this is reasonable. So Crystal, the big question here is, as Nathan has indicated, this is going to be something where you have to get a permit, DPW has to be notified of removal. Is it your sense that they have the authority to do this, given that these are street trees, or not? What did you find out about that?
It would be the Commissioner of Public Works who's got the authority under the charter to require, to either put in street trees or trees in the public way or require them to be removed if they are, unsightly, detrimental, or destructive to any highway, sidewalk, or public way. Then the Commissioner of DPW has the authority to have them removed. So there is some language in here that would need to be revised to address the fact that it is the Commissioner of Public Works that has that authority. He can delegate that, or he or she can delegate that to someone else, but it rests with the Commissioner. One thing that you guys mentioned about if it's a diseased or damaged tree, the only thing I would say on that is that we're going to want to add in specific language that at least allows DPW to make the call if there is not going to be an arborist certification required to show that it is diseased and damaged.
I think it needs to be done.
Okay. So I'm thinking on that, Crystal, that perhaps as part of the permit application, reason for removal, if we add language that the resident needs to provide evidence that this is a diseased and damaged tree, then that puts the onus back on them. to have information as to, because DPW does not have staff that are qualified to determine whether or not the tree is diseased.
I would be specific about what the evidence is. I wouldn't leave that up to a homeowner or a DPW to figure out what's sufficient evidence. I mean, an arborist certification, I see planning board approvals frequently require that if there's going to be a no-cut buffer and there's going to be a requirement and someone needs to take a tree out of a no-cut buffer. Typically, either there needs to be an arborist or the tree removal company has to certify that it is actually a diseased or dead tree. I think that the law should be specific so that it's not leaving ambiguity. The other aspect that you might want to take into consideration with this is that if there is a project that is going before a planning board and that the planning board is, going through landscaping and requiring that certain trees either be removed or put in place, that you may want to have that as an exemption to particularly the replacement fee, because it's becoming a requirement of their approval through the city, through another board.
So that was part of the old ordinance that was in place. This one is very narrowly focused on street trees. So this is not something where you're talking about, that was an issue in the discussion of the last one. But in this one, we're not talking about a situation where a developer is developing a plot of land, and in order to do so, they need to take down 6 trees. That's completely off the table in this. This is just about public trees.
But what if the tree overhangs the sidewalk?
In the new formulation.
In most circumstances, that's not going to be a scenario that happens with a plot of land and a developer needs to take down 6 trees. It's not like they have a plot of land, they're taking down trees in the interior of the land in order to build. That's typically what you see. So I think rather than worrying too much about that, if we just keep our focus on the street trees and clarify some form of certification for diseased or damaged, and then they have to apply for a permit and they have to replace or put money into the tree fund. And then that money can be used to plant more trees.
Yeah.
I mean, that's really the goal here, is to make sure we don't lose time.
Especially if we can already pay for
Yeah, exactly. So I can go back, Crystal, and make some of these modifications and get this out to you. Do you think we should bring this back to legal before it goes to the council next week? I think you're not modifications, are you comfortable with
Yes,
this?
I'm totally comfortable. I also just wanted to note, just like for the record, that the CAC never formally voted on this draft to be like explicit.
Okay,
So
so
it's all fine from my perspective.
I'll work on it around
Yeah.
and get it back to the
And-
CAC.
and- I don't think that there will be an issue.
Yeah.
To be clear, I just wanted to be
Okay.
clear on the process. This was more of an informal.
Okay.
Yeah.
All right, so if any public comment on the tree ordinance?
What is it, $300 and $500
Sorry,
fees in the
the
back?
replacement, the tree replacement fee is $300 per removal tree.
Then if they didn't do it, it's another 500,
Excuse me?
and then they didn't,
Um,
300,
if they-
another
if they-
500. No.
If they do not get a permit, they ignore this regulation, they have a fine of 500 in addition to the 300. So they have to pay 800.
So basically, if they're willing to pay $800, they can do whatever they want,
Yeah,
basically,
This is
Yeah.
true.
if they're so inclined.
but because we're using those monies to fund more trees, that's,
Okay. Sounds good.
and that's kind of how any
Net
funds work.
more, yeah.
I have, I don't know if this was the CAC that did this or if it was a bigger, if
Yeah.
it was the town, there's a sign next to the municipal parking lot on Union that has a layout, because it was a grant given, that has layout of the trees that were for this particular grant. That sign is so messed up now
Yeah.
that you can't read it. Was that through you guys?
If it was before my time.
Okay,
So, yeah, about 4 years ago, so.
Cause it is a mess, like you
Yeah.
put your hand on it and all of the paint comes off.
I know exactly which one you're referring to, and I have no idea where that.
All right.
So I don't see any hands raised. We're going to move on to, highway. So, you have two documents here. After, at the end of the day yesterday, I received a revised idling document, which is actually a local law related to idling. And I know that people had some comments on some of the issues with this. I also provided you, because I had sent out earlier the version, you know, the one that I said in the morning. So I sent you a track change so you can see what's different. The main difference here is that it is reframed as a local law. And also, there is an additional section that relates to, on the second page in the track changes, upon report of vehicle idling in violation of this ordinance. Police shall investigate, and I know that Crystal has comments on that. The person owning or operating the vehicle shall have 5 minutes from the time the police arrive and shut off the vehicle. One of the things that Crystal had mentioned to me earlier was exemptions, and when this first came up, which was before my time on the council, some of the issues concerns that were raised related to people with disabilities, and also extreme heat or whatever, and you have somebody who's in a car and you need to keep it running. So, Nathan, do you want to give any background on this, or is that sufficient?
I think that my sense of it is that, so I'm gonna be channeling Josh Cohen here, who led this work, not me, so I think he would speak to this better, but he can take it tonight. And so my sense of it is that this is modeling, there is a New York State I may not have this all correct, so forgive me if it's wrong. New York State has a statewide idling law that applies to certain commercial vehicles. There's sort of a gap there between private and commercial vehicles. This is modeled on a law that's been passed in New York City and Kingston, I believe, to expand that definition. And if I were to describe the discussion, there was a lot of discussion around this and like what to some of those exact points. And I think that also the degree to which it makes sense to have people like kind of calling the police on their other people in town. And so like there are some concerns around that, but at the same time, it is I think trying at least to reduce, you know, ridiculous, all the things that like
And the other thing to note, and Christy, then I want you to go through the concerns you had about investigating and so forth. The other thing to note is that when we apply for various grants, through environmental type grants, there are actually points awarded on the basis of what kind of code and what legislation you have that is environmentally friendly. And there are actually credits associated with having anti-idling.
Okay.
So it may be difficult to enforce, but having something on the books where we are at least addressing it, and if there is, you know, an egregious situation where somebody is idling, then it can be addressed. So there's some value to that. So Crystal, do you want to walk us through the concerns that you have?
Sure. So the only thing I went back through what was originally discussed, which was also before my time, for the original idling law when it was being discussed. And I also went through the EPA put together a compilation of idling laws throughout the entire country for different states, local governments, counties that have adopted them. And there is one common theme that I do see among all of, or most of those types of laws, and that's what Margaret had mentioned, an exception that applies for passengers that either have a disability or a health condition that could be aggravated if there is not temperatures being maintained in the vehicle while they are waiting. So think of it this way: if you've got someone who's saying wheelchair around that is waiting to, for something, the car's stopped, it's hot or it's cold, and you need to regulate heat. Same thing with young children. If you're waiting for someone to come out of, whatever it may be, and the vehicle is hot, it's hot or cold outside, you may need to maintain that temperature. So and those are exceptions. They're very clear when I've seen them written that they're the only exception for essentially passenger comfort is if there is a disability or a health condition that can be aggravated if the temperature is not regulated. So that is one thing that I did see repeatedly referenced. The only other one exemption that I saw repeatedly referenced that ours doesn't specifically have, but at the same time, ours also exempts from, I'm just going back to see it doesn't apply technically to vehicles and that are not, this applies to all motor vehicles that are not currently regulated. So this may not be much of an issue anyway. But the other exemption that I've seen is for regulations that are adopted at the federal or state level that already speak to maintaining specific temperatures for passenger comfort. And that typically applies to school buses, it applies to commercial buses, transportation, that type of thing. So we've got it where it's exempted under New York state law. I haven't had a chance to pull up that code, rule, and regulation that's referenced in here. It might cover the federal regulations, it likely does. But if it doesn't, that is another exemption that I would recommend putting in. And then the last part of this is I fully agree with the fact that you should have this at least be enforceable by police. I highly recommend that the term shall investigate be taken out of it and just have it be enforced, that it's enforceable by the City of Hudson Police, but not actually put in a requirement for investigation. There is a lot of, and this goes into even constitutional law, a lot of discretion that's granted to police officers when it comes to investigation. And going that step further and putting in essentially a requirement for an investigation, I just think that it leaves the city open to potential complaints and lawsuits, even if they end up being dismissed, dealing with that language.
So, Crystal, I'm looking at second page of this. There's a paragraph of enforcement. Any parking enforcement officer or member of City Hudson Police as hereby authorized to issue and serve an appearance ticket as provided in chapter whatever. I think we could potentially strike the entire paragraph that talks about if a vehicle is reported and police shall investigate. If it's not shut off, a citation may be issued. And just leave it at enforcement. They have the authority to enforce. And just leave it at that. Right?
I would agree with that, yes.
So we can strike that. Okay, so I think we need to make some revisions to this based on Crystal's input. Again, as with the tree thing, does anyone have any issues with the Island law, assuming we have exemptions for disability and competition, et cetera? Hang on a second, Dominic.
Yeah, I agree, Nick. I think Crystal grabbed it because I know the county bus on Front Street normally waits down there for more than 5 minutes.
Exactly.
So the other issue, I mean, I'm struggling with the private one, right? So if somebody has a car starter and they have a driveway and they start their car starter, whether it's for heat or whatever it is. So they're in a private property, private driveway. Now I have a neighbor who doesn't like me anyway. You're gonna get constant reports and on that. I have a problem with being in private driveways.
But the air is around that car is being polluted by your neighbor.
I'm not saying,
So
I'm just saying that-
it doesn't matter that it's on private property because it will go whichever way the wind is blowing. It's still enforceable.
I get what you're saying. I just, and I definitely think, especially for seniors, for example, where I work, we have, we deal with personal care attendants, right? And the personal care attendant does errands with their seniors or somebody with a disability. They go to CVS, they might park in front of CVS.
But they see they would be added as exemption.
Right, that's what I'm saying,
Yeah.
So the wording in that regard. But that's the same thing for the
Can I
private
suggest
driveway.
something?
What happens if a cab comes to me and is parked and I'm running, a little late or whatever,
That's the transportation part, I think.
but it's private, that's not public.
But they can also just shut their car off while they're waiting for you.
No, I think what Crystal mentioned earlier is that there's some laws that pertain to, that they're providing transportation.
Yeah, public transportation, yeah.
No, well, I
Well,
think
you-
we could
that
just
would-
say- we could just
a
say
taxi would-
transportation.
Okay, that fits, that's fine.
Right.
Okay.
And then the other part of it is, how tied are we to the 5-minute rule? Because many car starters automatically shut off at 15 minutes anyways.
right.
Can we increase that time to, I mean, ideally, I would like it so that it's not idle at all, but like that kind of removes a little bit of overhead as far as people complaining about a car starter. You restarted your car in the winter time, which, my mom does.
So Kristen, have you seen any where the time limit is 10 minutes?
Actually, one thing I did find in the prior attorney's files is he had collected the time differences for various other municipalities. I'm trying to pull it up now if I can quickly. I did notice that one of them was 10 minutes, some of them were 1 minute. I mean, it ranged. I have to look to see what the highest was and where that was, but there was definitely a 10-minute one.
Okay.
So yes, there is a higher range for some of these.
So then the other- I just want to say something about car starters. I don't know. I'm assuming that would mostly apply in cold weather, correct?
Or however, basically, usually car starters automatically have a limit.
No, but why would I use a car starter?
To either.
Cold or hot, yeah, to
So,
condition your car.
but so one of the things that's in here, exemptions are, ambient temperature of the city is continuously below 25 degrees.
Right,
That's
so
what we're-
that covers your winter part,
That-
right?
But maybe we add something here about the heat,
Mhm.
right?
Over 90 degrees and then.
So then that, like, the reason why you use a car starter is so that your car, when you get to it, it's not
Yeah, you're not uncomfortable,
boiling or
yeah.
freezing.
Yeah.
So that might address, Dominic, your concern. And we extend it to 10 minutes. Sorry. go ahead.
You're right.
Watch.
Just moving back to the minutes question, the two laws that we had based this on, New York City is 3 minutes, and Kingston, New York is 10 minutes. So
No, that's good.
just there's a relation.
So we'll make some of these revisions, we'll send it back to CAC. I'm gonna come to you live in a minute, I just want to check for hands. Okay, go ahead.
I would consider adding like animals as an exemption. And
You shouldn't have animals in
In
the
the car, no.
Yeah, that's already covered by state law.
It's
And we also added some.
yeah, it's a law.
And certainly agree with Crystal about the police having discretion, because every time they open an investigation, they get caught and short the paperwork they have to do. So we don't want them, having to chase me after investigation after investigation, and they should be able to use their own discretion.
So that's all I have on the agenda. On new business, we were going to talk about community aggregate stuff, but I think Kat is going to take that back and it may not need to come to legal.
Yep.
Still on the back burner, we are going to be re-looking at SGR and that legislation to see if we can make that a little better. Does anyone else have any new business they want to bring?
Yes, I had written to Crystal about, maybe a new law regarding pileup, which is payment in lieu of parking, so that we can start to charge developers when they are providing inadequate parking so that maybe one day we can try and solve the problem of inadequate parking.
Do you have anything to say on that, Kristen?
Yes, and I
need-
apologize for that. I started looking into it and then I haven't finished everything yet, but I can have that prepared for the next legal committee meeting in August.
It would be great if we could have just a little something by the parking committee meeting, which is, so we could just talk it through in the parking committee.
When's the
Um,
parking committee meeting?
It's the last week, the last Tuesday of the month.
Oh, yeah, that won't be an issue then. Yeah.
Yeah, okay. All right, great. Thank you so much.
Any other new business?
I'll make chime in Jennifer's thoughts there. Personally, I think any new developer should have adequate parking that they provide in their own development. I don't know if that's a problem or can't be done, but I'd much rather than set up a fund, just have to make sure they have enough parking.
Sometimes it's not, they're not
A
in.
caveat out here on this.
Yeah.
That currently, like, we do have to abide by what is in our code related. And so, if we want to revisit that, we would actually have to change our parking requirements that go before the planning board and so on, because currently we don't have those.
We don't have any minimums, I know,
Yes.
right.
And
So
then,
that was
Planning board.
2019 that was taken away.
and then didn't planning board come back with a letter saying that they want us to have?
They do want us to address it. Yes.
Great.
So
So I
we
think
should
I think
discuss.
it goes beyond, payment in lieu of parking to, let's take a look at reasonable, code relating to parking.
The thing is, I kind of agree with having the minimums go away in a way, because you don't want giant parking lots next
No,
to
right.
giant buildings
No.
and heating up the city and it's ugly. But having them pay us for what they're not providing so that we could maybe build a decked parking lot somewhere on the outskirts of neighborhoods, that would be good, I think.
Well, especially when a lot of times in the planning board, since there is no parking, part of their parking, that they, the developer does is they say, well, there's enough parking here, municipal parking. They use our city parking
Right,
as part of their plan.
exactly,
So,
which
Right.
really shouldn't be.
well, it's gonna run out soon.
Yeah. It's on its way.
Right, and because I know of two developers using the same parking.
Yeah.
So,
I do too. Yeah, it's bad. All right.
Any other new business?
No, just going back to the short-term rental.
Yes.
Is there any specific things that you were?
No, I want us to go back and look at, what we're trying to achieve and how it is currently written. Whether, I just think should have another.
Yeah,
So I think there's some things in there, that don't necessarily lead to, the kind of regulation I would like to see is we have a decision and we're only going to allow a certain number of percentage of short-term rentals in any given neighborhood, right? Any given block. To me, it's less of an issue whether, the short-term rental is on the same tax lot as the owner. I'd rather see the owners have to reside in Hudson, and they have to be within a few minutes of the independent properties. And then we make sure that no one area has more than a certain set number. That would be my preference for regulation. But I just want us to revisit it and to think about it and think about what are we trying to accomplish.
I can already see a problem with that
I'm
because,
sure that's why we want to discuss.
okay, let's talk about
Yeah, I mean, I just want us to go
Yeah.
back, or think about what
the way it's currently written is that there's obviously, ones that are grandfathered in doesn't count, but now you have to reside on the property to be able to.
Correct.
charge it. Yeah, and I think there was some thought about how that would significantly limit. But I mean, there's ways to get around it, because it's
Yes.
a certain number of days that you have to stay, you don't have to move.
Right, so this, right,
Private.
there's another one where you look, so you're here for 50 days of the year, you can rent your property out for
Yeah.
60 days.
Mhm.
So, and that's
Things to
kind
think
of
about,
arbitrary.
for sure.
So what I want us to do is kind of take a step back and think about what are we trying to do here?
Yeah.
And we also have to be cognizant of the revenue side of things. We want to balance,
Mhm.
not having things turn like at one point, a couple of blocks on Union, I had very few neighbors.
Yeah.
To me, that's what needs to be regulated is, I don't really care if, you know,
Person's living there.
out of 40 houses in a block, if the two that are short-term rentals are owned by somebody who lives in another part of Hudson, as long as they deal with the problems, that's fine.
Yeah.
What I don't want is 20 of the houses in short-term.
Sure.
So I think we need to think about what problem we're trying to solve. And then what is our best way to do that, balancing
Right.
the needs of the
I
community.
understand what you're saying.
Right.
Yeah, because I think the thought was that, initially the thought was that it'd be, mom and pop, you wanted to rent out a couple of rooms or like an apartment that you were own a house in. But I don't think, that might have been the intent, but that's not how people are
That's not
using that
true.
law. They're just saying that they live there, or maybe they do live there during the summer and then they rent it out for the rest of the year. And at the same time, you're not, so, yeah, I think it's worth looking at for
At
sure.
one point, 5 houses on each side, 10 houses, right? When I started out, there were people living everywhere.
Yeah.
And at a certain point, I counted it up, and in those 10 houses, there were 40 in that 10 houses.
Well,
I mean, it's an economic decision. If you could,
Yes,
if you could, rent out your property in Hudson and live in the country and still make a profit, why wouldn't you, right? But we're trying to solve the issue
Of housing.
having housing.
We have to have housing.
Right. So yeah, I think it's.
I just wanted to take it back and just, okay, is this working? What can we do better? That's all. Hey, if there's nothing else, motion to adjourn?
Make the motion. Second.
Great. Thank you all very, very much and happy July 4th.
Also, fried chicken.